please the court. The jury weighed extensive evidence during a 4-day trial and made findings that are accorded great deference. Uretek breached a sublicense agreement validly granting exclusive territorial rights. The jury could reasonably infer that Uretek's misconduct caused Ureleft to lower its price for the 4 projects and to miss out on the Chapultepec and Metrolinea A projects. The Mexican government chose the soil stabilization process that only Ureleft rightfully provides, but for Uretek's breach, Ureleft would have been the only source for that process in Mexico. At every juncture of the district court's opinion on lost profits, there was conflicting evidence that supported the jury verdict. As to liquidated damages, the provision easily satisfied the Phillips factors for enforceability, and as the district court found, Uretek waived the penalty defense by omitting it from the pretrial order and yet again from its Rule 50A motion. The district court also properly found that Uretek waived its attorney fee defense. Uretek did not mention the Covenant Not to Compete Act in the pretrial order. Instead, Uretek submitted an agreed proposition of law that attorney fees are available under the Texas Civil Practice and Remedies Code for breach of contract. That's page 1365 of the record. And despite plaintiffs' contention stating that plaintiffs are entitled to recover reasonable and necessary attorney fees from Uretek per the terms of the sublicense agreement, Uretek did not dispute the contention and submitted no contested proposition of law or fact on the Covenant Not to Compete Act or attorney fees, aside from stating plaintiffs' tort claims do not support an award of attorney fees. Those are pages 1356 through 1358 of the record. Okay. So as to the 4 projects, the evidence showed that Uretek-backed competition was responsible for Ureleft receiving that low price. And the court reasoned that Ureleft could not have been damaged by the Uretek-backed competition because also came into the marketplace as a bidder in September 2015. However, there was conflicting evidence on that point. In fact, Uretek-backed competition, the record shows, had an active presence in the marketplace before any of the 4 projects were awarded.
Where is the evidence that this active in Korea and whatnot was competing in Mexico during the relevant time of those 4 awards?
Sure.
Lower than they wanted it to be.
Sure. There are several pieces of evidence. I'll point out pages of the record 3465 through 67 and 3171 through 72. And that's evidence of the Uretek CEO meeting with Mexican counterparts, including the former disgruntled independent contractor of Ureleft, between July 2013, that's before any of the 4 projects were awarded, and October 2014 about pursuing Mexican projects. And then there's some very interesting and compelling evidence on pages 2441 through 2444 of the record, where this is a May 2014 email, where also is actively bad-mouthing Ureleft and its work product to Mexican government officials. And the email notes that the Mexican government already knows that the presence of Uretek's CEO in Mexico is as our consultant. And actually, also interestingly, in that email, they note that the government says because of the job done in December 2009, that's the STC project that Ureleft had done. Because of that project and its great post-injection results, the government is convinced that this is the right process and that it is willing to award a direct contract for use of that process. So that's another piece of evidence. And then, again, there's also evidence that at least as far back as 2009, no company other than Ureleft and also were able to complete soil stabilization projects in Mexico, much less use anything like the Uretek process. And that's page 3081 of the record. And as to evidence, besides all that direct evidence, circumstantial evidence has just as much weight, of course, as direct evidence and can be used to prove any ultimate fact. As to the Chapultepec project, here, speaking of conflicting evidence in the record, the district court set up its own litmus test that there must be evidence from a Mexican government official about the award. Such evidence could have been helpful, but its absence was by no means fatal. Project was awarded to also, as we know, a Uretek-backed company through a direct bid as the sole source for the Uretek process. The government found that process to be suitable, of course, and didn't invite competition So absent Uretek's breach, Ureleft exclusively supplied that soil stabilization process that the government wanted for the project. And again, as I noted, we have evidence that at least as far back as 2009, no other company other than Ureleft and also could complete these kinds of projects or use the Uretek process. That's page 3081 of the record. You know, it's kind of like Coca-Cola. They opted for Coca-Cola. If there's only one source for Coca-Cola, that can provide Coca-Cola, then anyone who needs or wants Coca-Cola is going to have to get it from that source. And here is the Uretek process, and the only rightful source for the Uretek process is Ureleft. So absent Uretek's breach, Ureleft would have exclusively supplied that process that the government wanted. And again, I'll point to pages 2441 through 2444 of the record, where the government where also notes that the government wants this Uretek process and is willing to award a direct contract for use of that soil stabilization process that, of course, only Ureleft rightfully provides per the sublicense agreement.
Because somebody has a sole source contract, which occurs in government contracting all the time when there's only one source, but it's rarely in perpetuity, so that you got a sole source, it means you're entitled to that for now and forevermore. People ultimately get in the marketplace, and then there's competition. So because you're a sole source at one point, doesn't mean, you get that all the time and then they claim profits because of that. I mean, that argument seems to run through as if sole source forever, and anything to the contrary is wrong.
Sure. Actually, the argument is not that sole source in perpetuity is what is warranted or needed. The argument is that the jury was entitled to make reasonable inferences. And there's plenty of evidence in the record that the only proper source, the only rightful source for the Uretek process, the only one that could actually provide this process was Ureleft. And that's what the government wanted. The government says that, government sees the history of Uretek successfully completing its projects. We have that again on pages 20.
One thing, we don't have any jury charge issues on appeal, right? So, this thing is tried all to the jury on all these claims, overlapping, yada, yada, them understanding the drilling process and on and on and on. So nobody's claiming that there was a bad jury charge that sent the jury down a rabbit trail or whatever, right? So it's just you both have your differing views on what the jury shoulda, coulda, did decide on the evidence, right?
There are no issues on appeal about the jury charge. And, the problem here is the district court substituted its own inferences that it found more reasonable for the jury's reasonable inferences. And of course, the jury is entitled to make reasonable factual inferences that support the verdict, and it did. And at every juncture of the district court's opinion on lost profits, there was conflicting evidence that supported the jury verdict. There was certainly evidence that the government wanted this process that only Ureleft could rightfully provide for its soil stabilization processes, and that it would choose, and it did choose that process again and again. The same thing happens with Metrolinia A. The government awarded that project to Also, but for Also's presence in the marketplace, and that's a Uretek-backed company, Ureleft would have been the only company that could provide the process that the government wanted and that the government chose.
Well, I grant you, we generally give high deference to a jury for absolutely perfectly good reasons. But the rules of procedure certainly provide that the district judge can, take away that if it deems, it's just not based, however perfect the jury charges were and so on and so forth, if there's not evidence. And lost profits is always problematical for us in a whole range of cases because it can be somewhat nebulous trying to figure it out, whether you got CPA and this and that and so on and so forth. So I hear you, and I guess that someone will have to read a lot of record. You're saying that the jury had ample emphasis, but tell me how the trial judge who's paying rapt attention when this same evidence is going to the jury, but whatever felt like there was not ample evidence on the lost profits for the jury to get there. So how do we conclude, other than you saying so, that the district court pushed the button and shouldn't have to take away the jury? I mean, it's not the case just because the jury does something, it just goes, no matter how much deference, right? But on the other hand, you got a fair point. The judge should let it be there or not. So just go straight to the jugular here where the judge derailed, should have kept hand off the button and let it on the lost profits. What is so inescapably true about the lost profits here that we'll say the judge erred by taking the lost profits away? You follow me? What reporting the evidence, what CPA's testimony, what deposition, so when we look at this, we'll say, well, we don't know how the judge could have read this and not concluded. You follow what I'm saying? So point us to where the judge should have seen it the way you do.
Sure. And interestingly, in the district court opinion, the judge highlighted only certain evidence. And it highlighted the evidence that may have, that it thought supported its own inferences, but there was other evidence supporting the jury's reasonable inferences. And if I have to point you to some compelling pieces of evidence, I've noted some already. I will also say for the Metrolinea A project, for example, which I haven't discussed yet. Again, I think actually one very compelling piece of evidence, time and again, for Metrolinea A, Chapultepec, again and again, is that the government chose this very process, okay? The government, and we see on page 2441 through 2444, government specifically wants that Uretek process, okay? The government wants that Uretek process, and it is awarding for Chapultepec a direct bid based on that process, and in fact, reports to also in 2441 through 2444 that the direct process will be available for this Uretek process because it totally works for our soil stabilization processes. The only company that can do that, rightfully, is Ureleft. So you get the Uretek back competition out of the market and only Ureleft is left. And for Metrolinea A, in the meantime, you see this evidence that even just days before the project is awarded, Uretek is still out there, and also its back company are bad-mouthing Ureleft to the Mexican government officials. There's actually an email from the Uretek CEO, and this is 4149 through 50 of the record, sending the government a letter denigrating Ureleft's integrity and work product and implying that Ureleft did not have exclusive rights to that Uretek process in Mexico. And that is the process that the government was choosing and selecting. So the jury could rightfully say, okay, well, we see the government wants this process. The government says it needs that process. And the only company that's going to be able to provide that process is Ureleft. So that's one way that we get there. That's one of many pieces of evidence supporting the jury verdict. And if you want to hear about disqualification of the bid for Metrolinea A, as I mentioned, there's the bad-mouthing Ureleft just days before, and the reasons are basically omissions of information. The other two bids there are ALSOs, which wouldn't have been possible but for Uretek's breach, and Comsa Emtes, which was disqualified. And there's evidence in the record that Comsa Emte never completed a soil stabilization process like Metrolinea A. That's 3081 through 82 of the record. It's reasonable for the jury to conclude that Comsa Emte was not qualified for the project. Okay, as for liquidated damages, unless there are more questions on any of these projects, sure. The provision easily met the Phillips factors for enforceability. Record shows that at the time of contracting, the harm caused by the breach was difficult or incapable of termination. We have evidence that UDEM is a holding company with no active business operations, that the Uretek CEO and president admitted that the exclusive right to sell the Uretek process and Uretek products in Mexico had value. And again, we also see that UDEM paid good value for these exclusive rights. It paid a license fee, other costs, and additional royalty. And these pieces of evidence are 2574 through 75 of the record, 3003, 3008, 3167, 3312. The amount called for was a reasonable forecast of just compensation. It's tied directly to the offending sales, calling for just a fraction, half, of gross revenues. This isn't Phillips, calling for a tenfold multiple of actual damages. Uretek did not at all establish any unbridgeable discrepancy between liquidated damages and actual damages. On appeal, it simply states that there are zero actual damages, which contradicts its own principles, testimony that the exclusive rights had value, and contradicting its own position in district court that damages were capable of determination because Blacker estimated UDEM's damages to the penny. Of course, Of course, Uretek later realized that these were actually Ureleft's lost profits that were awarded, so it had to change that were calculated, so it changed its tune on appeal. Also, district court properly found, and it has broad discretion in finding, that Uretek waived its penalty defense by omitting the issue from the pretrial order, and then yet again from the Rule 50A motion. Uretek's contested propositions of fact and law didn't state whatsoever that the imposition...
Raise the issue in the pretrial order?
Excuse me?
Didn't it raise the issue in the pretrial order?
It actually didn't. The only slight reference to liquidated damages in the pretrial order was plaintiff's damages claims show liquidated damages cannot be awarded. There was no mention whatsoever that liquidated damages were a penalty, were an unenforceable penalty. And of course, this court has held in Flannery and Allen and time again that a district court has broad discretion in narrowly construing a pretrial order. Here, it's not even close. The issue just wasn't raised at all.
So you like what the judge did about the liquidated damage, saying it's waived, but you don't like what the district court did to snatch the profits away. Is that it?
That's totally right.
All right, it's a good place to be.
But the snatching the jury charge is a de novo review, not an abuse of discretion like the other ones, right?
Okay, so abusive discretion, waiver issues are abusive discretion,
Right,
and that's...
but the snatching the jury, that's de novo, the question of insufficiency of the evidence. So
Exactly.
while we respect the district court greatly, we don't have to give any deference to that finding, right?
Exactly. The district court's factual findings on lost profits are subject to de novo review, as opposed to its conclusion of waiver for both the liquidated damages penalty defense as well as the attorney fee defense. Those are both reviewed for abuse of discretion. And
Well, you have a red light. Just trying to put a period behind it, but Judge Haynes gave you a plus to end on, so it's all good. But you've reserved your rebuttal time, so thank you. All right, Mr. Tabolsky.
Tabolsky.
Tabolsky, I'm sorry.
Thank you. Good morning, and may it please the court. The district court was absolutely right to grant judgment as a matter of law on Ureleft's claims for lost profits. For each of the three different elements of lost profits the jury found, there was no evidence of a crucial element, and that is causation. Starting with the 4 projects that Ureleft actually got, there is simply no evidence in the record whatsoever that can be either directly or that a reasonable inference can be drawn from that also or Uretek had anything to do with the bidding on what's called the 4 projects.
You tried the case?
I did not. Neither of us did.
All right, that's all right. Go, I'm sorry.
And I was just going to say, the argument about there being a lack of evidence is an argument you made before the jury, or someone made at the trial before the jury on your client's behalf.
That's absolutely true. We argued that there was no evidence that they didn't prove that anything Uretek did caused them to get a depressed price on the 4 projects. Certainly true.
And despite that, the jury made a finding to the contrary.
It did. And, why it made that decision? Perhaps it was unhappy with the defendant's conduct in the case. We don't know, but there still has to be evidence from which a reasonable inference may be drawn. And here, the principal of Uretek testified.
Do you think the jury was properly instructed on the law in connection with that issue in the case?
I'm not taking any issue with the jury charge, Your Honor. It is simply...
So the jury was properly instructed. They heard every argument you had to make about why the lost profits shouldn't be awarded.
That's certainly true, Your Honor. They did hear those arguments and they were instructed.
And they made an award.
They did. But that doesn't mean that there's not a role for the judge where sometimes juries get it wrong. And as an example, I'll point to this court's decision in Tercero earlier this year. The jury there awarded $12 million. The district court granted judgment as a matter of law on a number of issues, one of which was that it was speculation that the defendant's conduct caused the plaintiff to not get a new job. The plaintiff said that's what caused it. The district court granted judgment as a matter of law, took the issue from the jury, and this court affirmed. And here, people from Uretek testified at trial, people from SPI testified at trial, people from also testified at trial. Notably, Plaintiff's counsel at trial never asked any of them if they made a bid on any of the 4 projects. If they thought so, why didn't they ask the question? There is not a single piece of paper, a single piece of testimony anywhere in this record that suggests that also had any knowledge of the 4.
What about this ROA 2441 email? I haven't had a chance to read the whole thing right now, but I pulled it up. She argued that this showed that y'all were competing during the 4 awards, the lower price awards.
So, and I don't recall.
The May 2014 email with Brent and Luis Fernando.
Sure.
And
So the May 2014 email, there were communications starting in 2014. That's true. But what you don't see is any communication regarding any of these 4 projects. There is certainly communication regarding the Metrolinea A project. We don't dispute there is evidence of that in the record. But a jury cannot infer, because you were talking about this project in Mexico City, we can just infer that you were doing something over here about a project in a different state, in the state of Jalisco. That's a bridge too far. And that's speculation. And that's, the district court was exactly.
But I mean, if Mexico thought that Urelift was the only place it could get this stuff that they liked, and then they found out, no, we can get it straight from the guys that make it, that would make a difference in their approach, wouldn't it? And so if you make them aware of that in this email, et cetera, doesn't that start to get us down this path of you are competing and you're kind of throwing them in the bucket?
No, Your Honor, because we're talking about different governments in different cities and different states. The 2009 award they received.
Mexico.
I mean, yes, they were in the country of Mexico.
Okay.
I agree with that. But they got a project in 2009 to stabilize a rail line in Mexico City. The 4 projects, the 2 PSYOP projects that were awarded in 2013 and August of 2014, are in a small city, which I cannot pronounce, in Jalisco. And the GFB project, the 4th of those projects, wasn't a government contract at all. As Mr. Blacker, plaintiff's expert, testified at 3417 and 3418 of the record, that was a private contract where they're stabilizing some houses. And there's simply nothing in the record anywhere to suggest that also had anything to do with that. Whatever evidence there may be about dealings between SPI and also, or Uretek and also, the key factor that they had to put evidence in is that also did something with respect to the 4 projects. And again, plaintiff's expert, Mr. Blacker, at 3415 agreed that if also wasn't competing for those 4 projects, then Uretek did not cause any harm. So that's the key problem. Whatever's
You're saying just showing some yapping around isn't enough. You have to show that they were actually trying to get the project.
That's right. There was, Mr. Alvarez, Urelift's corporate representative, repeatedly testified we had competition on the 4 projects. And he would then try to say who it was. And every time the objection was sustained on hearsay grounds. And he said, well, we've got papers that show it. And as the district court noted, that paper never came into evidence, never arrived. There's simply nothing there that showed that also was involved in these 4 projects. No.
But you agree with your opponent that they did not have to put on Mexican authorities as witnesses. There are other ways to prove what they're trying to prove. Whether they proved it or not, is it your position they had to put on Mexican authorities as witnesses?
Do you mean like testimony from the relevant decision makers, or?
Yeah, I mean, get somebody from Mexico to come in and say, oh yes, we would have paid more, but for also applying or whatever.
Well, I mean, the Texas Court of Appeals in Toshiba Machinery Company versus SPM Flow Control, 180 Southwest 3rd, 761 at 779, certainly made that exact point that the best way to do this is to say, go ask the customer.
Well, I understand the concept of the bet. Of course, if they had brought in this Mexican authority and they had said that, we would not be sitting here. I get that. But that's not the question. The question is, did they have to do that? Not would it have been a good idea?
If you're asking, did they have to have direct testimony?
Yeah.
The answer is no. If they had emails or documents saying,
And you're saying this email isn't good enough.
no, because that email shows that Uretek and also are talking in May of 2014. The key thing that is missing as to the 4 projects is it doesn't show that also bid on those projects. There is nothing in the record to show that also knew of those projects, that also bid on those projects, that the decision made, that also had anything to do with those projects. And plaintiff's expert at 3415 admitted that if also wasn't competing for the project, then Uretek didn't cause the harm. And that's the problem. And I think it's an important thing to note, in order for the evidence to be sufficient to support the jury's finding on the lost profits, the $6.11 million, they have to show sufficient evidence of causation as to all 4 of the projects. Because $6.11 million was 100% of the damages that plaintiff's expert said was caused by the price reductions on all 4 projects combined. So even if the evidence is sufficient on causation is sufficient, any one of those 4, the motion for judgment as a matter of law ruling was absolutely correct. Because if one of those projects falls out, then you don't have all 4 projects there and you can't support the $6.11 million.
But then you would get perhaps a new trial, or you would get it remanded to the district judge to allocate that.
Not on this record, Your Honor. They chose, for plaintiff's trial counsel, only put in the lump sum number. They did not choose to put in the individual numbers of the 4. Moreover, plaintiff's counsel...
I'm not sure if you don't prove all the damages that you don't get any damages.
Well, I would say 2
What
things.
case says that?
Well, it's not that if you don't prove all the damages, you don't get any, but here, I would point out 2 things. First, the court in their brief, the only relief they seek is entry of judgment on this verdict. They haven't sought any alternative relief. Second, here, the plaintiff's trial counsel essentially invited the error. Plaintiff's trial counsel asked for the breakdown of the jury findings to be the 4 projects, Chapultepec, Metrolinear A. And then the district court did that. And Judge Johnson then asked the parties, does anyone have any objections to the form of the charge? And plaintiff's counsel asked that issue, said no.
But what case says if you did that and you proved 3 of the 4 but not the 4th, that you lose all 4 if you put them in the bucket, in one bucket?
Your Honor, I cannot point you to a specific case, but what I can say is when you choose, if you make a tactical decision to go all in and mix everything together, should another trial have to be held to redo the evidence and make another jury sit and figure this out? They made a tactical decision to present their evidence this way, and that's the record we're left with here. But to be clear...
Wait, when you said present the evidence that way, I thought you were talking about a jury charge in terms of how they asked for damages to be allocated.
2 separate things, Your Honor, and I was unclear. I apologize.
All right.
During the evidence, when evidence was introduced, the only way they chose to put in evidence as to the 4 projects is they just said, the 4 projects, $6.11 million. They did not put in evidence on a project-by-project basis. So then, when it comes to the charge conference, they asked the court to not just have a single general verdict on damages, but asked to separate it out. They asked for a finding on the 4 projects together. They didn't say, we want separate findings on each of the 4 projects. The reason they didn't ask for that is they hadn't put that testimony in at trial. That's how it matches up.
So you're saying that's the problem, there's the lack of testimony.
Correct. But the more fundamental issue is the one that Judge Johnson identified after an exhaustive discussion of the testimony. There is simply no evidence in this record as to the 4 projects that also had anything to do with them, and if also didn't make a bid or have anything to do with it, that breaks the causal chain. Moving to Metrolinear A.
So when counsel argued to the jury, they just argued the global the global claim. It wasn't broken down in their argument either. Okay.
That's correct, Your Honor.
Right.
During closing, they just said $6.11 million and left it there. Okay. There was testimony that the GFB contract, that was the private deal, that wasn't a government contract. The damages to that were only about $29,000. That was the last of the 4. That was the May 2015 project. So presumably the other damages are attributable to the first 3 projects between October 2013 and August 2014.
So you're the opposite of your opponent because you want us to affirm on something where it's a de novo review, but you want us to reverse on the things that are abuse of discretion. So talk to us about that.
Sure. And I would take partial issue with one of the 2 issues that I'm raising here being subject to abuse of discretion. On the liquidated damages, it is our position that the 50B ruling denying our motion for judgment as a matter of law, that the liquidated damages was unenforceable, that ruling is ruled de novo. In that ruling, the district court made no waiver findings. What happened is the district court ruled—
If you don't raise it in 50A, then you can't raise it in 50B.
Your Honor, I'll say two things there. First, we did raise it at 50A, and we discussed that in our brief. What happened here is before trial, the court said parties submitted joint pretrial order and trial briefs on March 1st. In that joint pretrial order, this is at 1153 and 1157 of the record, and it's also found at 1361 in tab 18 of our record excerpts, there was a general statement of a contested issue of fact whether UDM is entitled to recover breach of contract liquidated damages from Uretek for Uretek's breaches of the sublicense agreement. In the trial brief filed contemporaneously with that, we had 4 pages of argument making the exact same argument that we made at Rule 50, and that it was an unenforceable penalty, that they failed to meet their burden to show the elements to show that it's enforceable. In their 50, so at 50A, it was an oral motion, and we just referred back to our brief. In 50B, we raised it again, and the plaintiffs responded, but never raised the fact that we hadn't raised it in 50A. And this court has held that you can waive the waiver in this context. If the non-movement doesn't oppose 50B on the grounds that it hadn't been raised in 50A, then you waive the waiver. And we cite that case law in our briefing. But the more fundamental issue is we did raise it at 50A. We referred to the trial briefs, and that's at 3426 of the record. And to show that the district court understood that, I would point the court to a subsequent colloquy later that day at 3484 of the record. And this is when we're talking about the jury charge. And counsel for Uretek told the court, but I think we're going to object to any damages and then liquidated damages for the reasons in the brief, one of which is the Judge Johnson interrupts, cuts in and says, right, well, you've preserved that. The first time the district court suggested that it hadn't been properly raised in the pretrial order or at 50A was after judgment was entered and after the 50B motion had been ruled on. 3 weeks after the district court entered judgment, a new case came from the Texas Supreme Court called Atrium. And Atrium clarified what was unclear in the law before. And Atrium made clear, among other things, that it is the party seeking liquidated damages, it is their burden to prove that the measure of liquidated damages in a contract is a reasonable estimate of the damages. And there is no evidence of that in this record whatsoever. The only evidence we have is the formulas in the contract. Here's how the math works. Unlike Atrium, where they said 40%, we looked at our historical profit margins and the franchisor's historical margins, there's nothing here. So to get back to your original question, Judge, I don't think the waiver findings affect this court's review of the 50B at all. Had we not filed a 59E motion and just said, instead of giving the district court a chance to fix it, we just waited to come up here, I don't think we're talking about the pretrial order or the 50A motion because the district court didn't make those types of rulings in her ruling on our 50B motion. She just got to the merits and ruled against us. I would like to turn briefly back to lost profits, particularly the Metrolinear A project. As the Texas Supreme Court held in Horizon, it is not enough to show that someone got the project who wasn't supposed to. You have to also show that as a plaintiff, you would have received the contract. Now, there were 3 parties that bid on the Metrolinear A project. Also, Eurolift and Counsel. 2 of those bids were disqualified, including the Eurolift bid, for 14 independent reasons set forth. And you can find that document at tab 17 of our record excerpts, which is at also 4545 of the record. That is the only evidence in this record of why the governmental authority in Mexico made the decision it did. Eurolift wants to say, well, maybe that was a pretext. First of all, there's no evidence to say it was a pretext. They just want to say, well, we don't believe what the government said. The only evidence of what the government said and the decision maker said. But the key fact is even if the jury chose to say, you know what, we see that's what the decision maker put in writing, but we just choose not to believe that, as the Supreme Court held in the Bose case, simply discrediting that testimony doesn't mean you can infer the opposite. And the fact is there's still no evidence that Urelift would have got the job. There's a presumption baked into their argument, which is that all these jobs could have only been done with the Uretek process. Again, there's no evidence in the record to say that. We don't have the engineering specifications. We don't have the bid requirements. With respect to the 4 projects, with respect to Chapultepec, there's nothing saying, and with respect to Metro Linear, there's nothing saying it has to be the Uretek process. They simply are arguing because that's what was awarded, that must have been the only thing the government would have accepted. But you can't just, there's no evidence. And I would point to what the district court's colloquy with plaintiff's counsel at 3438 to 3439 of the record. And she specifically asked, where's the evidence that Chapultepec and Metro Linear A were choosing a particular process for stabilization? Plaintiff's counsel's answer was, well, you can presume it. We cite that colloquy also at page 41 of our brief. But there's a fundamental gap. As to the 4 projects, there's no evidence that Urelift had, or excuse me, also was even knew what those projects, was bidding on them, they were the competition. We don't know who it was. And you just can't, just because also may have been doing something over here, it doesn't mean they were doing it in a different state. And without also being involved in the 4 projects, there's no causal link back to Uretek. Because as their own expert testified, if also wasn't the competitor, there's no way Uretek could have caused the harm. So that's the fundamental problem we have here. Juries certainly have the right to draw reasonable inferences from the evidence. I don't deny that. That's clearly the law. But there is a limit to what inferences can be drawn. And here, the evidence went past that point as the lost profits, as the district court correctly found in her 30-some page ruling that went through the evidence. Unless the court has further questions, I'll sit down.
All right. Thank you, sir.
Thank you.
All right, rebuttal.
Just like to make a few points now. One, there is evidence that the communications between the CEO of Uretek and the Mexican counterparts, including the disgruntled former independent contractor of Urelift, started in 2013, and that's on 3171 through 72 of the record and 3465 through 67, and that's before any of the 4 projects were awarded. I'd also like to point out a statement was made about having no separate evidence on damages or anything on the 4 projects, and I would point to page 4206 of the record where it actually states the price of polymers. Well, where it states the price of polymers received for each of those 4 projects. Counsel mentioned the Tercero case, and I'll just note, if the court, in that opinion, this court noted that the plaintiff there did not name, explain, or describe the position she'd applied for or what its qualifications were, and concedes that she was a finalist for the position. So that case is not on point and certainly does not help opposing counsel. And as they've acknowledged, the jury is entitled to make reasonable inferences from the evidence, and here there was extensive evidence. And of course, circumstantial evidence is just as powerful and has just as much weight as direct evidence, and we've got both in spades here. As for liquidated damages, the district court properly exercised its discretion to find that Uretek waived its penalty defense in the pretrial order yet again.
What about the briefing? That it was in the brief and they referenced, because you're sitting there in trial and the judge just kind of wants to get through the 58. So, okay, I refer to my brief. Why isn't that good enough?
Okay, well, first of all, as to both the pretrial order and the pretrial order, it's just not in there, right? Uretek's contested propositions of fact and law state nothing whatsoever that the imposition of liquidated damages would be a penalty. There's a vague reference. Yes, later there's a vague reference to some earlier pleading. This pleading is not actually even identified, and of course, a trial brief is not the same as a pretrial order, nor is a trial brief a Rule 50A motion, and No
But
written.
you so you're standing there and the judge says, all right, we need to get going. Okay, what's your 50A? Go ahead, and please get to it. And you're, so you go, well, Your Honor, I adopt by reference my brief of, March 2. And the judge says, okay, thank you. I'll take it under advisement. And right, what about you? Okay, now we move on. Why isn't that good enough?
Okay, well, if we're talking about, this is now the 50A motion, so it's already been waived in the pretrial order, but once we get to the 50A motion, there's a statement, and they actually extensively discuss liquidated damages, but just don't make these arguments, right? There's no discussion that, the damages provision's unenforceable based on a lack of proof under the Phillips factors. They do say, as to contractual damages, we filed a brief on that. They don't say what brief, when, where, and under Montaneau, this court says that objections in a 50A motion need to be specific. Here, there's a vague reference to some earlier unidentified pleading, and in fact, if you even going to that brief, again, the argument is different than their argument on appeal, because over there, they're stating that damages can be calculated because Ureleft's expert and UDEM's expert calculated damages. Of course, those are lost profits of Ureleft and not UDEM. And so here on appeal, they recognize that and then make a completely different argument about being able to forecast damages. Okay, and also I would just briefly mention on attorney fees. I know I've discussed that a bit at the beginning, but also, interestingly, Uretek stated on page 63 of the record in its answer that the prevailing party in litigation relating to the sublicense agreement shall recover its attorney fees. And then, yet again, I would also note, as we've stated over and over again in our briefing and otherwise, the case was not tried under the Covenant Not to Compete Act. No mention of this act. And in fact, Texas Supreme Court has said that, has generally defined covenants not to compete that are subject and governed by the act as covenants that place limits on a former employee's professional mobility or ability to solicit former employers, customers, and employees. That's the ExxonMobil case at 452 SW 3rd 319. Obviously that is not at all what we have here. Are there any other questions that I might help to answer?
No, I think we've got it. Obviously, there's a lot of record territory to cover, and we'll cover it. There are some key matters that, not surprisingly, the two sides differ over what the record says, so we'll look at it closely and make the calls on the issues. So thank you for your briefing and argument. Thank you, counsel, on the other side. It's an interesting case, to put it mildly. I now know more than I wanted to know about subterranean drilling and so forth, but that's a good part of this job. We learn about a lot of stuff that we didn't know we needed to know otherwise. So anyway, but it's an interesting case. Thanks so much. The case will be submitted.
Thanks very much.
All right, before we call the third case up, Shepard, counsel can come on up to the table.